All righty, welcome everyone. Thank you so much for joining us this day. This is Saturday, September 14th, 2024. We are here for the Science Mind Archives and Library Foundation's second in a series of abundance preservation seminars. I'm Reverend Kathy Mastriani, and it's my joint honor to be a host of our seminar with you. And I know that if you're here in person or when you watch the recording, you're going to hear exactly what your soul needs to hear. And so we're so grateful for you. We're grateful for our special guests. And we're going to start off with an invocation from our beloved founder, Dr. Ernest Holmes. So I just invite you to just relax into this moment. Oh, take a deep breath in and allow Dr. Holmes to just take you away. And I invite you to mute your audio, and I'll keep it muted, and feel free to unmute when you're ready to speak. Thank you.
If you wish to be successful, you must identify yourself with success. That with which you mentally identify yourself sets up an image of thought in your consciousness, which tends to attract the situations with which you are mentally identified. If you wish to know the truth about your business or your profession, know that it is an activity of good. It is an activity of your partnership with the infinite. Lift to the load of personal responsibility by transferring it to the law of perfect action. No matter what confronts you, no matter what obstructions appear, or what undesirable situations exist, this law can dissolve them. Believing that divine intelligence is ever available, open your consciousness to its guidance. Keep your mind steadfast to the thought that you are governed by divine intelligence. Feel that you are impelled to make right decisions, that you are compelled to act upon these decisions intelligently. Turn resolutely from every sense of lack, want, and limitation, and declare that the perfect law of good is operating in, for, and through you. Say to yourself, through complete reliance on spirit, I calmly face all false conditions, seeing through them to that invisible reality which molds and recreates my affairs after a divine pattern. With a penetrating spiritual vision, I dissipate all obstructions, dissolve all wrong conditions. Standing still, I watch the sure salvation of the law of good. I know that my word transmutes and transmits every energy into constructive action, producing health, harmony, happiness, and success. I know there is something at the center of my being which is absolutely certain of itself. It has complete assurance, and it gives me complete assurance that all is well. I expect everything I do to prosper. I enthusiastically expect success. I let good flow into my experience. I am seeing good in every direction I look. I am looking forward to more good. I think with clarity, move with ease, and accomplish without strain.
So just knowing that these words of our founder, Dr. Ernest Holmes, are just flowing through the success of this wonderful workshop we have here today. I just know that each person who hears it, who experiences it, feels that sense of success and accomplishment, that they are guided to do exactly what is for the highest and best in their life, their estate planning situation, to just create abundance, and flow, to preserve it for their self, their family, their loved ones, and all that are valued in their heart. So I just know each person who is here is blessed. Our divine presenters are blessed. And we are just so grateful for it all. Thank you, Spirit. And so it is. Yay. Well, thank you so much. We're so grateful that you are here. Again, this is the Science Mind Archives and Library Foundation. We're a 501c3 nonprofit organization, and we are dedicated to preserving our science of mind history for us all. And we've been receiving just a number of questions about estate planning, and we just thought it would be really helpful to ask some experts in our field and in our organization today to help us learn about estate planning, wills. This one is specifically about wills and trusts and the tax advantages, and how to avoid some potential pitfalls with estate plan. And you are in for a treat. We have some just beautiful, wonderful souls here who are going to share from their experience and their wisdom and their heart. And so the way it's set up is I'll hand it over to our president of the archives, Dr. James Van Cleve, who will introduce our presenters. If you have questions, and we're looking for more general questions, please put them in the chat, and then we will do questions and answers towards the end. The presentation will be around 20 minutes or so. So without further ado, I hand it over to Dr. Jim.
Yes, well, good afternoon, everyone. This is being recorded, and per the first recording, the first session we had back in November, we had an awful lot of followers on YouTube. So we have to keep that in mind, and that regardless of who's in this today, the followers are much larger than that. As a matter of fact, I imagine some people would prefer to look at it on YouTube, because then they can start and stop and do things like that. But yes, I'd like to introduce our two experts who, and we can't overemphasize the need for licensed experts in this particular area. There are so many ways to make mistakes, and you need a professional estate lawyer. And we have with us Geoff Sindon, who has many years of experience in that, and has seen a great many things that people do that don't work out very well. And we also have Steve Gabrielson, who is not only a CPA, but a very prominent CPA in Southern California. Death and taxes do go together, and the estates, be it a trust, be it a will, always have some tax implications, and apparently those tax laws keep changing. So you want to get a professional to handle your the tax aspects. We also have with us Reverend Dr. Marilyn Leo, who is the founder of the archives, and very honored and respected for many years, written many books about religious science, and we're so happy. She's an emeritus board member, of course, and we're very happy to have her here. So the important thing is, now our two professionals are probably not going to push the archives, trusts and charities very much, but I can do that, and then when I turn over to them, they can talk about things that are accurate for any kind of a will or trust, whether or not charities are involved, and well, hopefully we would like them to be. The thing about the charity thing is that we all have, yes, we have heirs, but we also have values. And these values are us. That's our life. That's our ego. That's our, and I don't mean ego in a negative word. I mean, that's who we are. And if you have any feelings whatsoever for the preservation of the works of religious science, and for that matter, a lot of new thought to boot, if you have any value in your life for that, then please remember us in your will and trust. Now, the nuances of how you go about doing that and why you should do that, that is up to Geoff Sindon and Steve Gabrielson. So I think we should start with why should we do this? I mean, why don't you just let the kids handle it? Which is a question Geoff's going to tell you just how many people have trusts and wills, percentage-wise, and I think you'll be rather surprised. So, Geoff, you want to start
Thank you.
telling us why?
Let me introduce myself. My name is Geoff Sindon. I'm an estate planning attorney in Westlake Village, California. I've been affiliated with CSL and its predecessor, Religious Science International. Oh, I don't know, for 20, 25, 30 years or so, probably closer to 25. And I have a real love for CSL and for the archives and the foundation, and want to see those of you who may later view this understand a little bit better how you might provide for the foundation. I think, I don't mean to speak for Steve Gabrielson, but I think Steve and I are going to focus more on the areas of estate planning and perhaps some of the pitfalls of failing to properly make an estate plan. And we'll leave it to Jim and Kathy to deal a little bit more with the foundation and how and why you might contribute in that respect. Um, since I've started off, I think I'll just continue. And Steve, feel free to interrupt me anytime you like. And then when I finish the bit I want to talk about with the planning process, perhaps you could speak a little to tax law changes we may be facing and some of the pitfalls of failing to plan an estate. I'll let Steve introduce himself, but Steve, in addition to being a stellar CPA, is what we call a forensic CPA, which means he participates actively in legal disputes having to do with trusts and estates. And he's testified, I don't know how many times, he's an expert witness. So he has a lot of unique experiences I'm sure he'll be able to share in terms of failing to plan an estate. Many people put off estate planning because they think it only involves saving taxes or avoiding probate. Jim sort of alluded to that when he said, leave it to the kids to take care of. But that's probably the worst thing you could do, is just to leave it to the kids to take care of. Estate planning involves beyond what's going to happen after you're passed, also things that can happen to you during a lifetime. And you'll see many estate planning documents relate only to what might happen to you if you're incapacitated, either on a temporary or permanent basis, get old and need help because you're incapacitated, and those things happen. And a proper estate plan can not only provide avoid probate, which is what people talk about a lot, but also avoids conservatorships in many cases. And conservatorships, I can tell you, are probably worse than a probate in terms of the legal proceeding you don't want to be involved in. I've practiced now 48 years. When I began, getting a conservator was this, click a few snaps and in you go. Today, it's a whole different process. Court investigators get involved. There are many fees involved, and all those can be easily avoided in probably 90% or more cases with a simple but basic estate plan with the right documents in place. So that's basically what I'd like to talk about is the basic steps to getting ready to sit down with an estate planning lawyer and prepare an estate plan. And I think I don't say this to all my clients before they come to me for an estate plan. I handle estate planning, administration, and litigation. So I've had a pretty broad base behind me in terms of how I approach an estate plan. And I see many times people either haven't done an estate plan, or even in cases where they've done an estate plan, they haven't properly funded it and taken care of it, which create just horrendous problems later on. Just one example, a recent client came to me and said, I can't find my trust. And his wife had recently died, and the attorney apparently had died also. Nobody could find the trust. You don't want your family left in that situation if you have an estate plan. And if you don't have an estate plan, then that's primarily where I'm looking at in terms of explaining this basic process. Uh, we could talk for a lot more time than we probably have this afternoon to do this, but there are basically 5 steps to planning your estate that I'd like to just briefly touch on. The first, and I'll list them and then talk about them individually. The first is to identify your property. The second is to establish your objectives. The third is to select your advisors. The fourth is to draft and implement your plan. And the fifth really is for afterwards, which is to review your plan periodically. So let me just touch real briefly on these 5 areas. Identifying your property. I'm guilty of this to a certain extent, but organizing your key documents in one place is a very important thing to do. It's not just important in terms of preparing your estate plan, it's also important if there's an earthquake, if something else happens, if you're incapacitated and family members need to find your key documents. These are all very basic but very important things. And so I'm going to suggest just a few folders that you could put together in hopefully a watertight box or something like that, with your original documents being placed in a safe deposit or some other secure place. But readily accessible, you should have folders, which basically, I break them down this way: an administration folder, a business folder, a financial folder, a legal folder, a personal folder, a property and debt folder, and a tax return folder. Now, I'll say one sentence or two about each. The administration folder would hold your final instructions, letters of instructions to your family members if something should happen to you, and perhaps your safe deposit keys. Your business folder would have documents related to any business you own. So if you have partnerships or corporations or an LLC you're involved in, you'd put all those sorts of documents in there, together perhaps with business financial statements, life insurance policies, things like that. Financial folder is pretty crucial. All your financial accounts and account numbers, and maybe some current statements for your financial accounts along with your insurance policies. The financial folder is a pretty critical thing when you consider the fact that a lot of our financial life today is online. And that leads me to also consider in this folder a list of online accounts and passwords, and maybe a letter of instructions to whoever's going to be handling your affairs. And this is even if you're just temporarily disabled, to be able to be sure your business continues to flow. I don't know about you, but I haven't written a check for a regular bill in years, and most of us haven't. But having a list of what your accounts and passwords are is probably the most overlooked aspect that people deal with when someone passes. So that's the financial folder. Legal folder is going to have the obvious things: your estate planning documents, your trusts, your wills, durable powers of attorney, advanced healthcare directives, HIPAA authorizations, trust certifications. I'm taking advantage of the fact this is being recorded. You can rewind it and get these lists later. Trust certification, deeds to real estate, and title policies, and that sort of thing is in your legal folder. Your personal folder is going to have all your certificates: birth, death, marriage, prenuptial agreements, adoption certificates, things of that nature. Your property and debt folder is going to have registration, insurance, information about vehicles, loan agreements, mortgage agreements, appraisals for expensive property. And the tax return folder is going to have your recent federal and state income tax returns, gift tax returns, trust and fiduciary returns if you have any, and estate tax returns in rarer cases. So if you put all that together someplace, whether you go ahead and prepare your estate plan or not, you're going to feel a whole lot better if something should happen and you need to grab your key documents and have them in one place. Now, your personal objective, you have three objectives in step two, and I'll try to go a little faster. You got personal objectives, property objectives, and income objectives. For future financial decision making, this is the personal objectives. You want a trustee for your trust, an executor for your will, an agent for a durable power of attorney, an agent for an advanced healthcare directive, and if you have minor children, a guardian. There's special considerations with your personal objectives, caring for elderly parents, caring for disabled children or adults with special needs. Sometimes you have a special needs trust you may want to set up for either a child or an adult in some cases. And then protecting the interests of children from past marriages. We don't have all nuclear families anymore. Blended families have special considerations. And protecting the interests of a child from a prior relationship is often a consideration these days. Property objectives, minimizing taxes, avoiding probate, that's protecting your privacy rights, asset protection, and then the last and most important for our purposes today are your charitable intentions. Okay, selecting your advisors. You don't need all of these advisors in every case, but any of them may help you. An accountant, an attorney, a certified financial planner, an insurance agent, an investment broker, and a trustee. That's the range of advisors you could possibly use, whether your estate plan is large or small. Once you've selected your advisors, if you get past this step, if you're up to this step, you're more than ready to sit down with an estate planning attorney and your accountant to sort out your estate plan and figure out what you'd like to do. And the better prepared you are before you sit down, in many cases, the less expensive it is for you to prepare an estate. Drafting and implementing your plan is really the last step, because the final step I talked about before is reviewing it once in a while. You design the plan with your lawyer and accountant, sign your documents, fund your plan, write letters of instructions to your representatives, transfer ownership of assets to your trust, and then this is very important and often overlooked, coordinate non-trust assets like your 401k, your IRA, your life insurance policies with your estate plan. I have a client just last week, not last week, a client came to me a few weeks ago, and his business partner died, and he's the successor trustee. And as it turns out, he has all of these sundry accounts in different banks, all of which are designated with pay on death designations for his three children. At the same time, he's put large bequests to each of his three children inside his trust. The trust doesn't have any money anymore to fund these bequests. Now they will, because there's a piece of real estate that's going to be liquidated, but that means then that the children are essentially getting paid twice because dad didn't really coordinate his estate plan with his other non-trust assets. So that's a very important thing. Last thing I'll say, and then I'll turn it over to Steve. I really didn't give him a chance to interrupt me. Is to review your plan periodically. Key life events. When do you do that? Key life events: birth, death, marriage, divorce. Major income and estate tax law changes. Steve may touch on that. I know in 2026, we may or may not have some significant changes. And lastly, changes in beneficiaries or representatives might lead you once you've already gotten an estate plan in place. I will touch briefly on charitable giving. I don't know a single estate planning lawyer who will affirmatively raise the issue of charitable giving as a part of your estate plan. I'm sorry to say that, but unless you're affiliated with some organization you already are beholden to as a lawyer, it's not typically part of the territory. So I think it's important that people do consider making charitable bequests and for the client to be affirmative in suggesting it. If in your heart you would like to make some sort of a bequest, for example, to the Archives Foundation, tell your lawyer that because it's not a natural part of what the conversation would be. And they'll respect it. And the other thing I'd like to say is this. In terms of making charitable bequests, I would be very circumspect about making dollar amount bequests, especially if the dollar amount bequests are very high in amount. I've had situations where there's been much less money left in an estate at the end than people may have anticipated, and the gift is either more than they wanted to give or something along that line. And to prevent that, I'm just speaking for myself. You put two lawyers in a room, you get two opinions. But my opinion is that you're much better served by giving some percentage gift of the residual estate instead of some dollar amount, unless it's a nominal. If it's a smaller nominal amount, that's different. But if you're going to give 50, 100,000 or more to some charity, you might just want to be absolutely certain there's money already allocated to that before you complete your estate plan. So that's my little bit about how you can generally plan your estate. I hope some of the information will be helpful. Steve, maybe you could talk about some of these upcoming tax law changes we face and some stories you've seen where people have not done it right.
Yeah, thanks, Geoff. And I want to second everything that Geoff said there. Totally agree with it. In my career, I've been working in the estate field since the 70s. I was on the planning committee for the American Institute of CPAs Estate Planning Conference for 12 years. I've spoken at all the major conferences, what have you. I want to talk about what real life is like in working with clients to do estate planning. First example that comes to mind, client of mine that's been very successful as an entrepreneur. Been working with him for 2 years on estate planning with the law firm. We had our third meeting just this week, he and his wife. Meeting was 2 hours long, and the husband and wife spent approximately 1 hour of that arguing in front of us about how trustworthy their son was to take care of his 5 kids if they were both gone. So what happens, what I find that what happens in practice is that people procrastinate the issue of sitting down with professionals to do their estate planning. And then once they start, they frequently have very tough challenges making decisions and actually doing something. The very first estate that I worked on many, many years ago, it took the husband and wife 10 years to finally decide what they were going to do, because the husband wanted to leave most of the estate to his older son, who was responsible, and the mother wanted to split it equally between the responsible son and the irresponsible son. I also will throw in the mix here that as of this morning, the statistics are that only 1/3 of the people in the United States actually have an estate plan. What I have a lot of experience in is estate plans, what happens to them after somebody actually dies. A lot of stuff that really looks good on paper, or that's good theory, and you may even find it in books, actually doesn't work very well in life. One of the things that people do, they have trouble naming a trustee for their trust, so they name all their kids as co-trustees. If you only have 2 children, that might work. If you have 4 or 5, it's a really bad idea. You got to have somebody to be a leader. So, as Geoff said, estate planning is not only what happens after you die, but it's what happens before you die. If you become disabled, somebody else in your family becomes disabled. People die out of order. We had this big client in our firm for 20 years, always figuring that the husband was going to die first, and then the wife died first. Another estate that I'm working on, the mom gave all of her property to her daughter at one point, believing that the mom would be the first to die, and they had a very good relationship and everything worked out fine. The daughter's 33 years old, and then she died. So now the mom is inheriting back all the assets from the daughter. So the point there is that you don't know what's going to happen. You don't know who's going to get sick. You don't know who's going to become disabled. You don't know who's going to get Parkinson's or what have you. I had a construction company owned by 3 brothers, and all 3 of them have now died from Parkinson's after many years of struggling with that. So you want to have a good plan. You also want to run through and see how it's actually going to work. So Geoff gave an example there where the bank accounts are not made out correctly. That's why you have to have an attorney and a CPA or an accountant both involved. It's one thing to have the trust. And by the way, people that have trust, I say 99.9% of them, even the richest people in the country, don't even know what their trust says. They would read the first 2 pages and be so confused they didn't understand it. They need professionals to explain to them what it is. So if you have a plan that you think is good, you have to have somebody actually run the numbers and see if it actually works out. And in many cases, what they think they have as a plan doesn't work out that way. And particularly after somebody dies. And I've had instances, at least twice in my career, where a client that's very wealthy had a good estate plan, supposedly, that we weren't involved in helping with, by the way, in both cases. But we did the estate tax return when they died, and found out that the documents were deficient, and had to go to court and do what's called reformation of the documents after death, because the documents were so deficient. So you have to have a team, and you have to devote the energy that it takes to do it. Now, my final comment before we bounce it back into some questions and stuff here is that you never know what's going to happen, and you have to have documents that cover all the intricacies and possibilities, because you can never predict what the future will be. So I'll turn it back to Jim and Geoff.
Yeah, well, thank you, Geoff and Steve. Are we ready for a couple of, I mean, I get questions, and thank you, Steve, for pointing out the 1/3, because that is just a terrifying number. To think about 2/3 of the people in, I assume that's in the United States, are just, throwing their keys on the table and letting the kids fix it, more or less. And nobody believes when I tell them. I try to tell them, but I would like you two fellows to tell me, make it really clear. When I say anything over 184,000 or whatever the number is, you are probably going to probate, even if you have a will. Now, I don't know if that's totally true and how is it measured, but to most people that is a terrifying thing, because here in Orange County, at least, most of my neighbors are certainly worth more than that. So please put me to ease here.
Well, let me jump on that one first, and then I'm going to turn over to Geoff. Geoff will give you the technicalities of how what qualifies and when you end up in probate. I'm going to give you a snapshot of what it's like to walk into a courtroom in a probate setting, which I have walked in as an expert many times. You could have 100 people sitting there in the room. You're not going to be alone with a judge in your family doing this. The judge that's sitting up there on the bench may have 200 cases or more that they're in charge of. And they will call those cases, and they'll say case number 1. And the attorneys have to jump up and identify themselves. Your Honor, I'm here for case number 1. Okay, what are we here to decide? And that discussion may be 30 seconds. It might be 2 minutes. Or the judge might say, that's going to take 5 minutes to decide that. Why don't you come back in 6 months and we'll talk about it then? And so you're having all this discussion in front of basically a room full of strangers, all of whom are there for the same reason, for basically lack of planning or disputes that have happened. And it's one of the most chaotic things you'll ever see. It's like walking into the emergency room at the hospital and seeing 100 people sitting there. So, Geoff, I'm going to turn it over to you for the numbers and stuff.
Right. It's interesting Jim mentioned this $184,500, because when we first all got together to discuss preparing for today, that was something that Jim was particularly interested in. He's referring to a California amount of money beyond which you typically need to have a formal probate. And we're speaking about California law now. And if you're outside of California, there are still small estate exemptions with differing procedures in almost every state to accomplish the same sort of thing. But the reality is this: there are many different ways to orchestrate an estate plan. You can put property in a trust. You can put property in a bank or financial account, brokerage account, savings account, checking account, and you can make what's called a pay on death designation for those accounts, and that'll transfer it outside of any trust, outside of any probate, because it's designated that way. You can change, you can pass an account by adding someone as a joint account holder with you, which is an absolutely horrible thing to do because you don't really want to plan your estate by relinquishing control over your own assets. So I don't generally recommend anybody ever do that. But like I say, then you've got your non-trust assets. You've got your pension, 401k, life insurance, all those passed by contract, not by trust, not by probate. And that's why I say it's important to coordinate those kinds of assets with your regular estate plan. What people who need the basic dichotomy is between those who can plan an estate without any family trust and those for whom a family trust would be desirable. And that's a little different consideration than whether you've got 184,000 or not. Most of us these days, especially on the coasts and a lot of places in between, have a lot more than that by now. But if you own real property, it's generally speaking the best thing for you to do to set up a family living trust, a revocable living trust, and transfer your property to that, because that will avoid probate. And that will keep it. I mean, so there are a lot of other assets that you have that you may not want to designate that way. For example, you've got minor children. You're not going to make pay on death designate. My God, I had a client last week. He made his 11-year-old child one of the pay on death designation in all these accounts. So now I've got to set up a guardianship for that in order for it to be received. These things. So I'm getting way beyond the basics of what you asked, Jim. But it's not just a simple matter of how much money you've got here or there as to whether or not you want to have an estate plan. If you get disabled for some reason, you want an estate plan no matter how much money you have. So my suggestion is that you have at least basic documents in place, a will, durable power, advanced medical directive, and those sorts of things, whether you've got money or not. And if you've got money and you not have other plans for how it's going to be distributed out, then you're going to set up a family trust. And that's a basic thing to do. It's not that expensive. You're talking probably between $3,500 and $7,500, depending on the estate, typically speaking. And that's usually a one-time thing. And if you amend it later, it's not going to cost that much to amend. And I can tell you horror stories as to how much more money you could spend on the other side by failing to properly plan your estate. That's a longer answer than your 185,000. But I say that because how you hold the asset makes a big difference.
Yeah, well, thank you, Jeff. But I think it still goes back to the fact that those 65% or whatever, the people that aren't, that have no such thing, I mean, they just very well could be in trouble.
Hey, you could Google a 2024 Bank of America private bank study this year on use of the implementation of estate plans, and Steve's exactly right. It's 34%. And I can tell you since 1976, that's how long I've been doing this, that statistic has not changed. It has been exactly the same. Well, strike that. It goes up 2%, down 2%. But it's between 36, 37, and 33% forever, in my experience. So it is something to talk about with your family and to make sure you're ready for it. Don't we have enough concerns with long-term care and with all these other things that you should just get the estate plan done and over with already? That's my basic.
Yeah.
I'm going to jump in with one other comment here. I think all human beings want to be considered, respected and loved by their, children, grandchildren, what have you. I can tell you from experience that all the adults that didn't plan their estate and follow the guidelines that Jeff did, they become very unpopular with their family after they pass away, because the professionals that they go to at that time will say, "Oh, well, your dad should have done this, it should have done that, what have you," and all the ramifications of not doing the planning then fall on the family, and it's discussed because they all want to know, well, how much did I inherit, and how soon do I get it, and what have you. And after about a year or so goes by, a lot of the people who were held very highly in esteem by their family while they were alive are not that way anymore, because the last thing that ever happened after they passed away was the family was put into a certain amount of chaos. And what can happen, worst case scenario is you have family members suing each other. And I have seen families that supposedly got along well. And I always say, you never know how well the children really get along until mom and dad are both gone. But I have seen families spend $1 million, $2 million, $3 million, $4 million in legal fees fighting each other after mom and dad are gone.
Wow. Well, I think I think you answered my question on steroids. I mean, that's incredible. I, before we switch subjects, there was a real quick question. I think it was for Steve about something that's happening with tax law in 2026.
Yeah. So we have a very favorable lifetime exemption now. It came in with the Trump tax cuts. It's supposed to go away at the end of next year. And so what a lot of us in the profession are doing right now, we're keeping a very close eye on the presidential election. It's going to have a huge impact on whether that law is actually allowed to sunset or not. I think if the Democrats end up in control, that the lifetime exemption is going to go way down and probably stay way down, because it's not popular among the Democratic viewpoint to give wealthy people too many tax breaks, and the opposite is true for the Republicans. So there's going to be, I think, a lot of gifts made next year in anticipation that the law will actually sunset at the end of the year, to take advantage of the large lifetime exemption. But that's only one of a myriad of things that you need to consider in an estate, because actually right now, and for many years, the most important part of estate planning is income tax planning. It's what is the tax basis of those assets that are going to come out of the estate, and how much in taxes you're going to have to pay, when they're sold. So that is a change that's, potentially there. Right now, it will happen unless Congress does something to change it. And you're going to hear a lot about that right after the election, because whoever gets elected as president, the word will spread quickly as to what is likely to happen with that estate tax exemption and the estate tax law.
What, I'm sorry, what's being exempted, and how does that work? I mean,
If you have a lifetime exemption from estate taxes, and it's over 10 million at this point, it's like 12 or 13.
13.4.
Say again?
13.4 million this year.
Yeah. I never memorized the exact number because it's kind of meaningless. But anyway, that means that you can have that amount of property and not pay taxes on it on the first death. And if you have a surviving spouse, you won't pay taxes on the first death. But if you make the mistake of not having an estate plan, as Geoff said, and let's say the first spouse dies, leaves all the property to the second spouse. Now the second spouse's estate is double. And then if the law changes, all of a sudden you got a situation where the second spouse is going to, when they pass away, there's going to be a tremendous amount of taxes. So there's a certain amount that you can pass away with and not pay taxes on it. But there are many complicated issues to look at, whether you actually are going to take advantage of that, or want to take advantage of that, or leave your property in such a way that you're going to get a second step up in basis when the second spouse dies.
well, back before the Trump administration, what was the limit there?
I think it was 5 million.
Okay.
Yeah.
So most people really aren't affected at all, I would think.
If
Well,
if nothing happens in Congress, and they let the law sunset that now exists, then beginning January 1 of 2026, the new exclusion amount will be approximately $6.4 million. And that's it's really a little less than that, but adjusted for inflation, that brings it up to that. If you have a husband and a wife, that's double that number. So you'll have $12.8 million for a typical family unit that's excluded from estate tax. The challenge is that no one really knows what's going to happen. I've heard experts tied right into senators in Congress. A professor out of USC, I listened to a talk he gave, and he said, don't be so sure anything's going to really change, because his prediction was they were going to leave it intact at the higher amount that it is now. In 25 years ago, there were approximately 325,000 annual estate tax returns filed with the IRS. Last
Yeah.
year, there were approximately 24,000. The IRS doesn't really want hundreds of thousands of estate tax returns, but the tension against that is that the government wants money. So where it all shakes out, we'll wait and see. I have read a proposal that Biden had for after 26, and that doesn't mean anything at this point. But they were actually starting by opening the gambit at a $3 million exemption, $3 to $3.5 million exemption, which was even lower than by just letting it expire.
Yeah.
Nobody really knows. Nobody really knows.
Yeah.
But
So I need to jump on that. This number that we're kicking around here and everything Geoff said is totally accurate. It's one of the reasons why a lot of people haven't sat down and done their estate planning, because they're under the impression that they don't have anything to worry about because the exemption is so high. There are hundreds of things to consider in your estate plan other than what the estate taxes are going to be, because with good advisors, you can basically make any estate tax optional. You can figure out ways to get around it. You still need all the planning and everything that Geoff said up front, regardless of what the exemption is. And I've seen more screwed up estates since that exemption went up and people stopped planning than there was before, because they became very lackadaisical about it. Oh, we got this big exemption, now we don't have to worry about it. That's only one of just dozens, not possibly hundreds of things that have to be considered.
income taxes are just as important, if not more important, than estate tax.
Exactly.
And planning the estate and the planning step-ups in value, which are so far still existing, is a critical thing. I can't tell you how many kids I've seen with elderly parents going into assisted living. They say, well, let's sell mom's house. And mom bought the house 35 years ago, dad's gone, and the tax basis on the house is like way from 30 years ago. If they just hang on to the house and rent it while mom's in assisted living, when mom ultimately passes, they get a step up in the basis to date-of-death fair market value. There's no capital gains tax. And there are a lot of people that have held houses for 40 and 50 and 60 years. And they're just foolhardy to not go forward with some professional advice.
Yes.
I know people who think they were very smart for downsizing because they're getting older. And of course they paid a huge tax, and now they wonder where the money went. But
Sometimes
Kathy, I think you were
right.
trying to phrase a question. If let's say the exempt amount gets in half or whatever, giving money to charity, was that your question? I mean, can you avoid this problem by simply giving money to charity? And we may have one or two in mind. Was that your question, Kathy?
Essentially, just what are the tax advantages? Because I love that Geoff pointed out a lot of people don't even the attorneys aren't going to bring up to give to charity. So it's really up to the person to look into their heart, and if they want to give to a nonprofit, to bring it up. But what are their tax advantages to doing so?
Well, I'll go first on that one. I'll give you an example of one I'm working on right now. These numbers are kind of big, but the woman died. She had no surviving spouse, no surviving children, no surviving relatives. She left 40% of her estate to her next door neighbor. She left 40% of her estate to her broker and the other 20% to 5 charities for dogs because she was a big dog owner. Had she not left the money to the charities, she would have had substantial taxes on her estate. Because she left that money to those 5 charities, the taxes are 0.
This is where integrating your non-trust assets gets very important, because sometimes this happens through an IRA. You've got an IRA, which is pre-tax. And if you use the IRA to make a charitable contribution, that can often be beneficial from a tax perspective. I'd have to defer more to Steve for tax impact.
Yeah, that's a topic that we covered extensively on the first seminar a year ago, and I think the archives will make that link available, so anybody that wants to know more about that can listen to that one.
Right, yes, we do have the YouTube site, and yeah, it was covered very, very well on IRAs. But my question is, how could the archives sell it? In that, how could we go to someone that is obviously in that category, they're worried about estate taxes, and tell them that now's the time to fund us a significant amount of money, and I believe that if somebody gives us $1 million, and that's not out of the question, I'm sure, but is that's 100%? How's the tax thing work? Is it that year? Is it the estate? I mean,
all right. So I'll give you a quick answer. It would take me 90 minutes to give you all the permutations on that question. The answer is it's deductible, and anything that isn't deductible currently would be carried forward. You're not going to get 100% of it in any one year while you're alive. If it's deductible, if it's paid after you die, it's 100% deductible immediately from your estate. Geoff, you want to pick that up from there?
And it's going to be deductible against income, don't forget. So it's not like you're just taking it. I mean, that has to be a factor that's taken into the equation. That's why pre-tax money that's not yet been taxed, is usually resorted to for charitable giving these days, because it's a no-brainer. Because if you take it out of the IRA, I mean, just using IRA as an example, if you take it out of the IRA, you're going to get taxed on it based on whatever your rates are, but you're going to get taxed on it the minute you take it out. I mean, here's an example. Let's say you've got somebody who's got IRA income they don't need. They're really well heeled, and they don't really need the IRA money. But they've got required minimum distributions each year they're required to take. One way to get an ongoing stream of income for the foundation would be for that hypothetical person to designate the foundation as the beneficiary each year of the required minimum distribution. And then that becomes a deduction instead of a taxable amount. And I think that's right. And by the time you're done, there hasn't been a realization. And so it's pre-tax income being gifted, you see. So
that's exactly right. One of my longtime clients died last year, and he had some gigantic IRAs, and he never paid a dime in taxes on the IRA money because he gave large amounts directly from it has to come directly from the IRA directly to whoever the charity is. It's called a trustee to trustee transfer. And he made the largest donations that I've ever seen anybody make out of their IRA, and he never took $1 for himself.
Well, I'd like to meet that person, but I mean, if it's appreciated property, I mean, let's say it's stock that you paid $1 million for and it's worth $10 million now. If you donate, do you still have to pay the long-term capital gains on that stock?
No, it gets a step up in basis to date of death in general, but you can then deduct it as a charitable deduction from your estate.
Okay, suppose you haven't died yet.
Okay, if you haven't died, the worst thing you can do is sell the property and then give the money to the charity, because you're going to pay taxes on it, and then you're going to have to pay it out of the other. There are rules where you can donate appreciated property and not pay the taxes currently. There's
Okay.
a specific rules you have to follow on that.
It starts in a person's desire to give in the first place, and reminding them of charitable intent. And because, as I said, in a legal context, you're not going to hear it. So if you in your heart want to provide for continuing the legacy of Ernest Holmes and Science of Mind, then it starts there, and then you go from there to how much and how to implement it. And there are ways to do it during lifetime. There are ways to do it after you've passed, and there are too many permutations. I mean, we could do a whole other session on alternative ways to give to charity. Uh, there are charitable remainder trusts, for example. There are charitable
Yeah.
lead trusts. There are all these very sophisticated things. But in general, if you just start with somebody's desire to give, then in the smaller estates, they're going to remember to give in their estate plan. And in the larger estates where it makes sense, you're not only going to get a larger gift, but a tax-wise gift for the giver.
Yeah, I want to endorse one other thing that Geoff said. I've been sitting in estate planning meetings for almost 50 years. I have never heard one attorney ever bring up the issue of would you like to leave something to a charity? If the client brings it up, they'll do it in a heartbeat, but they never bring it up on their own.
Well, and I think one of the big takeaways for me is it helped to have that team that Geoff talked about, to select advisors and to really have a well-versed team that can really guide someone the best way to set up their estate plan. So I'm really grateful for this wisdom.
Yeah, your sundry advisors won't generally collaborate by themselves. That's kind of going to be your job. You've got a CPA, you've got a CFP, you've got a lawyer. They don't typically initiate collaboration with estate planning. In bigger cases, obviously they do, but that's pretty much do your homework. That's why I started with the basics, with just putting your key documents together. If you do that, you're 50% of the way there.
Yes, I'll give you a war story on that one. Collaboration among advisors. Um, this is an estate that just came in a couple months ago. The person that died had 3 IRAs totaling 750,000. He went to his attorney and got his estate plan done, set up a trust, and he said to the attorney, "What should I do with the IRAs?" And the attorney said, "Name beneficiaries, don't name the trust." Okay, so he then left, and sometime later, he named the trust as the beneficiary of all 3 IRAs. The trust was drafted to say nothing about what the trust was supposed to do if it got IRA money. So I called up the attorney. I said, "We have this money coming in here. What is your recommendation?" He said, "Well, I told the client to not do it, so I didn't put anything in the trust to cover that." That's an example of not collaborating and sharing information between the advisors.
Well, thank you. Thank you again. And Geoff, you've mentioned the charitable remainder trusts and the other different kinds. Those have been there've been a lot of questions asked of me about that. How do we, if I have a big windfall, how do I avoid, paying taxes on it by taking my next 10 years of contributions and lumping them all together somehow? And I think that's one of the vehicles you're talking about. But I think we talked about a third session, and why don't we think about that some more for a while? So Geoff, you're quite familiar with those vehicles of charitable remain, whatever the
Well,
words are.
larger cases. We haven't done them for several years because it's not set up quite as it used to be. The charitable remainder trusts, they're pretty interesting in a lot of ways. Uh, Clients, though, are sold charitable remainder trusts often because can create a flow of income during life while still having a charitable residue. and unfortunately, a lot of them get gamed, so that the idea is to leave as little as possible to the charity at the end. But the IRS and Congress are really starting to toughen up on that. So charities, I think, can expect to see some more out of, they call them CRETs, charitable remainder annuity trusts. Yeah, we can talk about it. The field narrows as to who they apply to as we get into the more sophisticated state.
Well, if there's pitfalls to be avoided, that's all the more reason for having another session.
Well, I'm not suggesting we shouldn't talk some more.
All right, wow. This was exciting stuff. Reverend Kathy, what do you think? Are you about ready to say why or what they should be doing for charities?
Well, I've been just really blessed here being the executive director of the Science of Mind Archives to talk to people who have called us about their estate planning. And what they looked at is their life. We're infinite beings, but we have a limited time on this earth plane. And so when we leave, what legacy do we want to leave? How do we want our estate to benefit others, to continue, especially like the Science of Mind teaching that has touched and transformed my life and so many lives. And people I just feel in their heart when they think of giving to the Science Mind Archives, they feel so good because they're helping to preserve our Science Mind history and our legacy, so it can help their children and their children. And we've been around 100 years, so it could be around for the next 100 years. And it touches my heart to talk to those folks, because it really is a feeling. It's an emotional thing when you want to give a piece of your estate to someone, and to feel really good about it is, anyways, people get to go into their own hearts and what touches their hearts. And the Science Mind Archives is a 501c3 nonprofit, and we are here, and we would be very grateful to receive any estate gifts. I've been very blessed. So this is so timely for me. I'm about to get married, and we're just starting to go through our own estate planning. And we've talked, thanks to these conversations, talked to an attorney, we talked to a financial advisor, and I've put the Science of Mind Archives in my will. And I love what Geoff said about percentages. And that was the recommendation too, because that way it's simple. It's simple for the people who are managing the trust to give. And I just know in my heart that my gift is going to carry forward and help others.
Well, yes, okay. What, Kathy, did you have more to, I guess we did that in the first session. You talked about the archives. Did you have more to, well, things have changed now because we've moved to Unity Village.
Yeah, but we've been around. I mean, thanks to Dr. Marilyn Leo, who we're so grateful is here. It was in 1998 she started collecting the history of Ernest Holmes. She's a neighbor of Dr. Ernest Holmes, and was the perfect choice to start an archive, a history, a collection. And it has just grown and grown and grown to the point where we just had to move from Golden, Colorado. We moved to Unity Village, Missouri. We had 2 tractor trailers filled with 45,000 pounds and over 900 boxes, plus furniture of our Science of Mind history. And it was interesting as we were setting it up, Jim, I asked for like high-level guidance on organizing it. And he said, goosebumps. When someone walks into the space, for them to feel goosebumps. Honest to goodness, he planted a fertile seed, because people walk in and they'll either burst into tears or they say, wow, I feel God bumps. Just looking around and feeling the history of Science of Mind, and such gratitude that, the archives is doing that sacred work of preserving it. And it's not just keeping it in gray archival boxes, it's scanning and digitizing it and making it available to everyone, and to get it out to the world on our website and through our different programs. And so I do invite everyone, if you haven't, to just go to sciencemindarchives.com, get our e-newsletter so you can be up to date on all the things that are happening. We have monthly lunch and learns where you can hear Ernest Holmes' voice. But it's just something really special when you, like we started off, you can hear Dr. Ernest Holmes, or when you read little known works that the archives is making available to everyone. It's very special. It's a special place. And we're grateful for everyone, how you're bringing Science Mind out to the world through your legacy, through how you just treat people with love and oneness and respect. And I'm just wondering if Dr. Marilyn has any words to share.
Yeah,
Oh, I think that this was extremely informative. And even though I just renewed my trust and my will and those papers, I have received magnificent and wonderful thoughts and ideas and direction on things that I should be doing or I should have done. And I really want to thank both of you for all of the information that you gave us today. And I know we've run over time, but it's just been so wonderful and so informative. So thank you both very, very much.
Thank you, Dr. Marilyn.
yes, indeed. Thank you. Thank you. I mean, it's a treasure trove of information. I'd like to wrap up my piece of it. We recently took another look at our vision and our mission. And we had two vision statements, but one of them is our vision is to be a treasury of inspiring and expanding resources for the growth and evolution of timeless wisdom and consciousness. We used to be a collector of books and dust, but we decided a few months ago that we are the teachers to bring forth. CSL, they just announced closing the Holmes Institute, which was one of the greatest teaching centers in New Thought. And so now we're it, or that is, we're the teachers. You may not know that the tape you heard earlier that Kathy put out, there's over 100 such Ernest Holmes tapes like that, I'm told. And they're all available from the archives. And I think most of them are $1 or $2. And if you're a subscriber, they're free. So, you know, that's what we do, is we're getting the word of Ernest out digitally. And of course, Dr. Hornaday and Raymond Charles Barker and people like that also. So, yes, we are running a bit over, but I think it was all really good. Kathy, do you have anything you want to, how should we close this one up?
Well, I'm happy to end with a benediction. I just wanted to see if there's any final words, if Geoff and Steve, if there's anything on their hearts. You're good? All righty. Well, thank you all for being here. I just am grateful for everyone who has watched this video, for our beautiful presenters, Dr. Marilyn, Dr. Jim. And let's just go to that place of gratitude where there's a lot of thoughts we've been thinking. If we can just move to that beautiful place of our heart space, that place of love, that place that just expands with every heartbeat. We just feel gratitude and love. And we share that gratitude and love to Steve and Geoff and Jim and Dr. Marilyn, and for just the entire Science Mind Foundation, Science Mind Archives and Library Foundation. We're just so grateful that Dr. Ernest Holmes just brought this wisdom to this earth plane for each one of us to benefit from. Just grateful that this teaching of Science Mind just continues to expand all around the planet and the world, just uplifting the consciousness of the planet, uplifting each and every individual and collective consciousness of joy, abundance, prosperity, love, and peace. So I just know that the words that we have spoken this day are planting fertile seeds in each and every mind, that divine mind, where people are just called to go within, to look at their own estates, their own families. What is it they want to give to nonprofits that touch their hearts, that people are inspired to treat and move their feet. They treat of what is the highest and best, and they concerted action. They create that team. They do those 5 steps to identify your property, establish objectives, select advisors, draft and implement a plan, and review their plan frequently. And that this carries forth to truly deep peace, where they can have peace on this planet, knowing that their trust and their estate is so well cared for, and it goes forth to honor their personal wishes in amazing ways. So I know this and so much more has unfolded from this conversation. And I just say thank you, Spirit. Thank you so much for this opportunity and this time. And I just release these words into the divine law that just says yes, yes, yes. And we can just anchor it by saying, and so it is.
So it is.
So it is.
Mhm.
And
Thank you.
Jeff, I like your 5 steps. We know something about 5-step prayers, don't we? So anyway, thank you once again, Steve, Jeff,
Thank you.
Dr. Marilyn.